sasa nitakupeleka katika shoroba za mahakama ambapo kuna ile kesi ya naibu jaji mkuu Philomena Mwilu ambayo inaendelea kwa sasa, na tupate kujua hatima yake ni ipi haswa ambayo itakuwa inatolewa leo mahakamani.
Professor Benson, President Mr. Jack Awele, I'm President of the Legacy. Mr. Dudley Ochiel, President. Mr. Eddie Leonard Obai, President. And Mr. Jacqueline Leroy. Madam President, I apologize for this beautiful. For the amicus, Mr. Charles Mongela. And for the interested party, Mr. Morris Kimuli. Present. Mr. Justice Munyevia. Present. Jennifer Mutua, Miss. Present. Ms. Joan Mati. And Mr. Chin Ogenga. With the commission of the respondents, my friend Mr. Dr. Suduro, SPT, Mr. Alexander Muteti, SADPP, Mr. Victor Witty, Prosecution Counsel, and Ms. Mwamburi. Ms. Mwamburi.
Present,
and for the third respondents, Mr. Emmanuel Bita. He's not here. Mr. Oscar Heredi. Not here. And Mary Murudi. In the hands of the court.
Thank you. We have the judgment already. It is a long document, and we hope you would understand if we did the introduction and went into the analysis to save on time. We hope that is agreeable to all.
It's agreeable.
It's agreeable. Thank you. So by a petition dated 29th of August 2018, the petitioner, Honorable Philomena Mwilu, moved this court against a backdrop of charges that had been instituted against her and the interested party in Nairobi Chief Magistrates SEC number 38 of 2018, Republic versus Philomena Mwilu, and another. The petitioner had been arrested on 28th of August 2018 on the basis of investigations by the second respondent. She was presented before court for plea on the same afternoon. The plea was deferred to the 28th day of August 2018. On the day scheduled for plea, however, the charges were not read out to the petitioner following an application by her counsel for deferment of plea on the basis that a petition had been filed before the High Court challenging the actions of the first and second respondents. This is the petition now before us for determination. The petitioner therefore seeks the following reliefs. 1, a declaration be and is hereby issued that investigations on the petitioner by the DCI and the DPP's institution of criminal proceedings against the petitioner in criminal case number 292 of 2018, Republic versus Philomena Mwilu and Stanley Muluvi, Kiima violates her constitutional rights, is an abuse of the court process, and therefore unlawful, null, and void ab initio. 2, an order of certiorari be and is hereby issued to quash the entire charge sheet dated 28th August 2018 and proceedings against the petitioner in SEC criminal case number 38 of 2018, Republic versus Philomena Mwilu and Stanley Muluvi Kema. 3, an order of prohibition be and is hereby issued prohibiting the respondents from proceeding with the prosecution of the same case. And 4, an order of prohibition be and is hereby issued against the IG, DCI, and DPP from investigating, recommending the prosecution, or commencing any prosecution of the petitioner in respect of the said case. She has also prayed that the costs of the petition be provided for. We have considered the pleadings of the parties, their respective submissions, and the authorities that they rely on. We note that the petitioner alleges violation of her constitutional rights under the provisions of Articles 27, 28, 47, and 50 of the Constitution, and contends that the charges against her are based on an ulterior motive with a view to removing her from her position as the Deputy Chief Justice. The respondents counter that the charges are brought in the enforcement of the criminal law in good faith, that there is no intention to remove the petitioner from office, and the charges are premised on solid evidential and legal basis devoid of any extraneous considerations. Having considered the petition and the matters raised before us, we believe that the following issues arise for determination. 1, whether there is a factual or legal foundation for the charges against the petitioner. 2, whether the DCI and DPP followed due process in initiating the charges against the petitioner. 3, whether the DPP has acted in contravention of Articles 157(11) of the Constitution. 4, whether the DCI and DPP have encroached on the mandate of the EACC. 5, whether the comments by the DPP amounted to trial by media. 6, whether the intended prosecution of the petitioner amounts to an attempt to remove her from office in contravention of the constitutional process for removal. 7, whether prosecution of the petitioner should await a decision of the JSC. 8, whether there has been a violation of the petitioner's constitutional rights in the initiation of the charges against her. And 9, whether the court can grant orders to the interested party in this petition. I will hand over to the next judge to read the next portion.
Before we enter into an analysis of the above issues, we begin by reiterating that it is a constitutional petition in which the petitioner alleges violation of constitutional rights. Underlying all the issues identified above and the petitioner's challenge to the exercise of the powers of the DPP and DCI is the contention that these actions infringe upon or will result in the infringement of our rights granted under the Constitution. It is therefore prudent to consider first the burden that is placed upon a party who alleges violation of constitutional rights under Article 22 of the Constitution and who seeks redress from the court in respect of such violations. It has been established in various decisions by our courts that a person who seeks redress under the Constitution must state his or her claim with precision and demonstrate with the provisions of the Constitution that have been violated will infringe or that the matter of the alleged violations. This principle was established in the case of Wanarita Karim in jail. We all know it. I'm not going to read that. So this is the quote here. The principle was reiterated in the case of Nene versus Republic in 2004. The principle has also been stated, and those principles were reenacted in the case of Trusted Society of Human Rights Alliance versus the Attorney General, which we have also reproduced in this judgment. In Mumo Matemu versus the Trusted Society of Human Rights Alliance and others, the Court of Appeal affirmed those principles in the Anarita case and we have restated them in this judgment. It's a long quote. The petitioner has alleged violation of Articles 27(1) and 2, 28, 47, and 50 of the Constitution. Article 27 guarantees to everyone the right to equality and freedom from discrimination. The provision relevant to the present matter are as follows. Article 27(1), every person is equal before the law and has the right to equal protection and equal benefit of the law. Equality includes the full and equal enjoyment of all rights and fundamental freedoms. Article 28 provides every person has inherent dignity and the right to have that dignity respected and protected. At Article 47, the Constitution protects the right to fair administrative action and is in the following terms. I think Article 47 has been reproduced here. The final provision of the Bill of Rights that the petitioner alleges a violation of are Articles 50, Article 2A, B, C, J, and K, which protects the rights of an accused person in the following terms. Every accused person has the right to a fair trial, which includes the right to be presumed innocent until the contrary is proved, to be informed of the charge with sufficient detail to answer it, to have adequate time and facilities to prepare for a defense, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence, and to adduce and challenge that evidence. The petitioner also claims that the charges against her have been brought in contravention of Article 157, Article 11 of the Constitution. She accuses the DPP of ulterior motives, malice, abuse of process, unreasonableness, and irrationality in making the decision to prosecute her. Article 157(6) provides that the DPP, whose office is established under Article 157, Article 1, shall exercise the state power of prosecution. In exercise of such power, the DPP is required under Article 157(11) to have regard for the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. We now turn to consider the issues identified above in order, and in doing so, we shall consider whether the material placed before us demonstrates the alleged violations of fundamental rights and guaranteed under the cited articles, and whether there has been contravention of state power of prosecution. This is yet another case in which the DPP's decision to mount prosecution in exercise of its constitutional powers is under challenge. The petition therefore ignites the debate on the role of the court in checking that the DPP's discretion and the power to prosecute is not abused vis-a-vis the public interest, that the DPP's constitutional mandate of commencing criminal prosecutions is not unduly hampered by intervention by the court. When the basis of the challenge of this decision is on the legal and factual foundation of the charges preferred, then the debate often revolves around the scope and depth of scrutiny to be undertaken by the court, and that debate is present in this petition. Not surprisingly, the opposite side to this petition do not agree on the approach which the court should take. We are urged by the petitioner not only to interrogate the process in which the charges were brought, but also to the merits of the decision to mount the prosecution. The court is asked to take a cue from the holding of the majority in the Court of Appeal decision in Njuguna S. Ndungu, the Ethics and Anti-Corruption Commission, that in matters of this nature, the court is enjoined to make tentative and objective findings in the legality of the charges and the prospect of a conviction. An approach that, though not a trial, involves a scrutiny of the proposed evidence in the context of relevant law. The DPP, DCI, and AG, on the other hand, call for a more restrained examination. They contend that the court's power to prohibit prosecution should be exercised sparingly and in the clearest of cases. We are beseeched to remain the neutral arbiter and refrain from making orders that amount to an unnecessary fetter on the DPP in the discharge of his constitutional mandate. In pressing the argument that the court should not assess the merits of his decision, the DPP cites the decision in Matalulu and another was the DPP, in which the court held that this would have proper regard to the great width of the DPP's discretion and the polycentric character of official decision making in such matters, including policy and public interest considerations, which are not as susceptible to judicial review because it is within neither the constitutional function nor to the practical competence of the court to assess the merits. This approach subsumes the concerns about separation of powers. End of quote. We observe that our jurisprudence is replete with decisions which identify with this non-intrusive approach on the basis that courts must grant a measure of deference to the DPP's exercise of procedural discretion. Such decisions include Tuitha Mwangi and others, and Ethics and Corruption Commission, and the Republic versus Commission of Police ex parte Michael Monari, in which the court addressed the matters germane to the mandate of the police to mount investigations and stated, is a long quote, I will reproduce it. Yet, the orthodoxy of the proposition that judicial review on the DPP's decision should confine itself only to the process has come under some strain lately. There is an emerging view that a substantive review of the exercise of the DPP's decision must necessarily involve an assessment of the merit of the decision in the context of the threshold set for the DPP by the Constitution. In this regard, the decision of Onguto J in Republic versus the Director of Public Prosecution and another ex parte Patrick Kogola Onyango and others becomes handy, and we are reproducing a long quote of that decision. That in fact is the method, the approach advocated for by the Court of Appeal in the decision of the majority Njuguna S. Ndungu, in which the court held as follows. I have referred to the reasoning of the High Court at paragraph 9, 10, and 11 above. It is apparent that the High Court left the matters raised by the appellant and the respondent to the trial court for determination without making any tentative and objective findings on the legality of their charges and the prospect of a conviction. The jurisprudence shows that the standard of review of the discretion of the DPP to prosecute or not to prosecute is high, and the courts will interfere with the exercise of the discretion sparingly. In Diamond's case, the court said at paragraph 42 that the burden of proof rests with the person alleging unconstitutional exercise of prosecutorial power. However, if sufficient evidence is adduced to establish a breach, the evidential burden shifts to the DPP to justify the prosecutorial decision. In a Diamond Laiji, the Court of Appeal which is cited in Njuguna S, which the court cited in Njuguna S, held that in considering the evidential test, the court should only satisfy itself that the evidence collected by the investigative agency upon the DPP's decision is met, establishes a prima facie case necessitating prosecution. At this stage, the court should not hold a full-fledged inquiry to find if the evidence will end in a conviction or acquittal. That is a function of the trial court. However, a proper scrutiny of fact and circumstances of the case are absolutely imperative. The state of Mahasharashrat and others, it quotes another decision from India. We agree that there is a real danger of courts overreaching if they were to routinely question the merit of the DPP's decision. However, there are circumstances where the type of scrutiny set out in the majority decision of Mwilu Esendungu is called for. Should there be credible evidence that the prosecution is being used or may appear to a reasonable man to be used for an ulterior or collateral motive other than for advancing the ends of justice, then a scrutiny of the fact and the circumstances of the case is not only necessary but desirable. This is because it would enhance the administration of justice if the charges were to be properly tested so that any fears of ill motive are dispelled. To be underscored is that judicial review of the foundational basis of charges should only be undertaken when an applicant has first established that there are reasonable grounds that the challenge proceedings are a vehicle for a purpose other than a true pursuit of criminal justice. To allow a willy-nilly and a casual review of the foundational basis of criminal charges would be to turn judicial review proceedings into criminal mini trials, a prospect that anyone keen to stop a criminal trial will relish. The question is whether the present case fits into the latter scenario. At the very heart of this petition is the allegation that the charges against the petitioner fall into a pattern of retaliatory action by the executive against the judiciary following the majority decision of the Supreme Court that annulled the August 2017 presidential election. It is not disputed that soon after that decision, the President made public utterances in respect to the court judgment. He said of the judiciary, "We shall revisit this thing, we clearly have a problem." The respondents do not deny that these very public remarks were made by the head of state, the head of executive arm of government. The petitioner asserts that events which followed reveal a systematic and sustained effort to carry out reprisals against the judiciary as an institution and the majority judges in that decision. She takes the view that the commencement of the prosecution against her is part of this scheme, and she enumerates these events, including a petition lodged by Honorable Ujiri Wabugu with the JSC for removal of the Chief Justice on 14th of September 2017, a petition by one Derek Malik Kangumu for the removal of the petitioner and Chief Justice Isaac Alenaola on 18th of September 2017, the shooting of the petitioner's driver while with the petitioner's official vehicle on 24th of October 2017, and a petition by one Adrian Kamoto Njenga for the removal of the Chief Justice and the petitioner on 26th of February 2018. As we indicated at the start of this analysis, the petitioner has a duty to demonstrate that the alleged violations and contraventions of the Constitution has a duty to demonstrate the alleged violations and contraventions of the Constitution. The petitioner has not presented any evidence before us to show that these events were either instigated, orchestrated, or coordinated by the executive arm of government. Further, no evidence has been presented to show a connection between the various events. We are also aware of the constitutional dictate that in performance of his prosecutorial functions, the DPP is to act independently, free from directions or control from any quarter. We have no reason to doubt the DPP when he says that in the matter before us, he acted independently and without internal or external directions. Further, there is no evidence to suggest that the DCI was directed by the executive to investigate the petitioner and or to reach a particular result. There is no evidence placed before us of conspiracy or connivance between the DPP and or DCI on the one hand and any other person on the other. That said, the commencement of the prosecution was against the backdrop of a very public utterance by the head of the executive that there shall be a revisit on the judiciary. Of course, it is not in our place to second guess what the president meant by revisit. We cannot possibly know whether the revisit, whatever it meant, was to be followed through or was merely a statement made in the heat of the moment, later to be forgotten. Nevertheless, the person who spoke the words is no ordinary mwananchi. He is the head of the executive branch of government and wields formidable instruments of power. A person against whom such remarks are made by the head of state would be forgiven if he or she were to be troubled, nay, terrified. This court cannot ignore the possible perceptions held by the ordinary man of the utterances made by the president. In this regard, the following observation by Obola J. in Hassan Ali Cheho as Inspector General of Police is not without significance. For avoidance of doubt, the presidency is a powerful institution in our constitutional democracy. Under Article 131, Article 1, the President, Head of State and Government, the Commander-in-Chief of the Defense Forces, the Chairperson of the National Security Council, and is a symbol of national unity. Whether the President says anything, when the President says anything, it is reported over and over again. His words, even if disputed, retain the power, respect, prestige, and honor of the presidency. The President's utterances can also be taken out of context by various governmental and political actors, depending on what the actors intend to achieve. The rest of the quote you will read. The effect of the revised remark was to put any action by the executive that may be perceived to be prejudicial to the judiciary or its members under great public scrutiny. In this regard, it is noted that the petitioner is not only a senior member of the judiciary, but is one of the 4 judges who rendered the majority decision that prompted the remark by the President. Public attention would be piqued if any action was directed at any of the 4. Under Chapter 9 of the Constitution, both the President and the DPP belong to the same branch of government, the executive. The DCI also falls within the executive branch and is an appointee of the President. While, as stated earlier, no material has been placed before us to give us reason to doubt that both the DPP and DCI acted independently, the petitioner expresses apprehension that the two were acting at the behest of the President. Given that the President and DPP and DCI are members of the executive, which is headed by the President, the apprehension may not be unreasonable. It is in these circumstances that we deem it appropriate and hold that it is in the interest of administration of justice that we carry out an inquiry into the merit or otherwise of the petitioner's contention that the charges against her are without legal or factual foundation. Such an inquiry may help to dispel any notion that there is intention to drag the petitioner through a criminal trial simply because of a judicial role in the decision of the presidential election. As we turn to that inquiry, we are alive to the caution that we should not engage in a full-fledged scrutiny, or put differently, in a mean trial. We must not get involved in a miniature of fact-finding exercise. To do so would be to trespass into the mandate of the trial court. Yet, delimiting the scope of the inquiry is easier said than done. However, we take the view that useful but useful in drawing the line is the standard